Welcome to today's Modern Criminal Law Review event on lawfare in comparative context. I'm very excited to introduce later on our distinguished international interdisciplinary panel, but here's just a quick introduction to the subject. So for some time, the term lawfare has spread throughout the domestic political, legal discourse, jurisprudence, and scholarship of countries and political systems in Latin America, notably, but by no means exclusively, Brazil and Argentina. Increasingly, it's being invoked in various senses and for various purposes elsewhere around the world, including recently in connection with the criminal cases involving Donald Trump and his associates in the US. At this moment in time, today's event will bring together an international interdisciplinary panel of commentators to investigate domestic lawfare and its rhetoric from a wide range of perspectives across a number of national, regional, and systemic contexts. Today, we'll explore questions like, what is domestic lawfare? Where does it come from? Is it a new phenomenon or as old as law and war itself? What has it been used for and by whom and how? How does lawfare relate to other familiar concepts or labels such as rule of law, fake news, enemy criminal law, war on crime, war on terror, or more prosaically, cause lawyering? In the end, is lawfare a fruitful topic of thought and study? Does it have normative bite, analytical power? Can it shed more light than heat? Today's event is scheduled for 2 hours. It consists of 2 panels with 4 speakers each. Each speaker will have approximately 10 minutes, and each panel will be followed by 20 minutes of discussion. Anyone joining us on YouTube is welcome to post their questions or comments in YouTube chat at any time. The selection of online resources is available on the Modern Criminal Law Review website, and event proceedings will appear in a special online MCLR Plus forum later this year. But now let me briefly introduce today's international interdisciplinary panel. There is Gautam Bhatia, who is a lawyer, scholar, and author based in Delhi, India. Manuel Cancio Meliá from the Universidad Autónoma de Madrid in Spain, where he teaches law. Stephanie Dennison joins us from the University of Leeds in the UK. She is in Brazilian studies. Siri Gloppen from the University of Bergen in Norway, government. Friis Hau from the University of Copenhagen, Denmark, and sociology. Rocío Lorca Ferreccio, University of Chile, Santiago, law. Tyler McBrien, managing editor, Lawfare US, and Valeria Vegh Weis from the University of Buenos Aires and the University of Konstanz, Germany, law criminology. So let's get started with our first panel of 4 panelists who will have 10 minutes each, followed by 20 minutes discussion. Valeria, I'm going to turn it over to you.
Well, thank you very much for inviting me and for putting together this amazing panel with people from almost all over the world, different regions, trying to discuss which are the commonalities and differences about this new phenomenon of lawfare, or even if it's new or not. In this very brief presentation, I will try to state again very briefly which is the connotation of lawfare in the global north. Then I will relate it with how I have conceptualized that in terms of how lawfare works in the global south. I will then share some open questions with all of you, and I will finally propose some indicators that we can apply in order to assess whether a criminal law case can be framed as lawfare or not. All of this is work in progress that I am trying to share with you. So please feel free to make comments and provide feedback in the Q&A because it will be really helpful. So as you may know, lawfare didn't come up via the academic discussion, but it emerged in the United States with US Air Force Colonel Charles Dunlap. He was the one that used the term lawfare, presenting it as a negative phenomenon and a byproduct of the hyperlegalism deployed by other countries other than the United States and by the international community to delegitimize the US interventions abroad. and which put US national security at risk. More precisely, Dunlap argued that the origins of lawfare could be found in the international reaction to the NATO bombing of Kosovo and Serbia in 1999. Nevertheless, we also know that several years later, Dunlap reconsidered this stand and presented lawfare as a neutral tool that could even be useful for the United States in its own defense of its geopolitical interests. And this is also the stand that many other scholars adopted since then. Today, the term, as you were referring, Mark, has reappeared in the US public debate with a different meaning, constrained to domestic politics. And we can inquire, could it be that this new meaning, this new connotation that the term lawfare is acquiring in the US debate has been shaped indeed by the conceptualization of lawfare developed in the South in the meantime? Let's explore this a little bit in depth. So indeed, from the periphery, actors in Latin America have, particularly since the detention of Lula, current president of Brazil in 2018, reshaped this contested concept of lawfare. There are many definitions that have been developed ever since, but I want to share some of my own theoretical considerations. We can frame lawfare as it was displayed in the Global South, and particularly in Latin America, as a new format of persecution and repression executed through judicial actions extensively covered by mainstream media and social media as aseptic investigations against corruption and misgovernance, but which have the purpose of delegitimizing progressive actors, expelling them from political life. This persecution takes place through a warlike approach that conceives the other as a political enemy without the right to access a rule of law-based treatment. Regardless of the existence or not of actual corruption, lawfare does not respond to a commitment to fight corruption or misgovernment, which would need structural and institutional changes aimed at deterrence and with a focus on transparency and monitoring. Instead, lawfare works as a political war through judicial medial channels and is driven by judicial, economic, political, and geopolitical interests hidden from public opinion. Moreover, the effects of a lawfare case are not limited to the indicted individual. Instead, it can be as decisive as deterring a political leader from participating in elections or holding office, affecting the foundations of liberal democracy for all of us. The final comment that I want to share with you in terms of conceptualization is why are we using a term that is in English, like lawfare, to define something that indeed is not related with the conceptualization that was originally made in the Global North. So I suggest that we might be able to think, to reflect that another concept in Spanish might be also very useful. I argue for the concept of golpe por goteo, dripping cup, arguing that even if the target of lawfare or dripping cup, golpe por goteo, is presented as a political adversary devoid of the right of a fair legal process, the objective isn't necessarily a conviction. Rather, it seeks the political and legal demise of the opponent, effectively delegitimizing or barring them from the political arena. Thus, it does not require solid charges, but it's based on the trickle of smaller allegations, which may even consist of frivolous claims without evidence presented in the courts or the media, despite the legal impossibility of these accusations advancing to prosecution. In sum, I am referring to a dripping cup because the aim is not necessarily to convict, but to shape democratic politics through the misuse of criminal law, criminal procedure, media, and social media, undermining the already limited basis of liberal democracy. Many questions can be raised after this conceptualization. Is the same lawfare than criminalization of activism? Here we have Professor Cancio Meliá. Can we see points in common between lawfare and the enemy criminal law? How does lawfare interrelate with the emergence of right-wing extremism? Is lawfare a new phenomenon, or is it indeed a historical phenomenon that has now a different shape? We will be able to discuss all of this in the Q&A, hopefully. But there is one precise question that I do want to approach now, and is whether lawfare actually targets only progressive leaders. We are now seeing these discussions in the US, And also Trump appears or allegedly argued that he's a target of lawfare. So how can we know, how can we assess whether a case is a case of lawfare or is it a legitimate process against corruption or misgovernance? How can we de-ideologize this in order to actually assess whether a case can be framed as lawfare or not? And this is because this conceptualization of tripping coup that phrases lawfare as a manipulation of each country's criminal justice system to harm progressive leaders based on accusations of corruption and related crimes, and that started with Lula in Latin America, is one definition. But others argue that indeed describing these cases as lawfare is an attempt to undermine the legitimacy of actual valid criminal processes against corruption. And this can be seen indeed in the fact that these processes have been applied to both left and right-wing leaders. So to finalize, I want to share with you some indicators that I am trying to develop in order to assess whether a case where a political leader is indicted, it doesn't matter from which side of the political spectrum or in which point of time, can be framed or not as lawfare. I developed 3 indicators within criminal law, 4 indicators within criminal procedure, and finally 5 elements or sub-indicators in terms of the use of the media and the social media from a criminological perspective. So very briefly, when we talk about criminal law, in order to assess whether we are in a legitimate case in terms of corruption or misgovernance, or we are in seeing or confronting a case of lawfare, we can assess whether there is a use of open criminal types, like conspiracy, treason, abuse of power. We can also check whether there is an extensive application of criminal types. For example, if the person has been imprisoned for the crime of rebellion, which entitles violent actions aimed at rejecting the Constitution and overthrowing the government, but indeed has been calling for a peaceful anti-neoliberal protest. And third, the expansion of authorship and distribution of responsibility in the governmental hierarchical change, because we have been seeing that in many cases that have been framed as lawfare, the person that is higher up in the hierarchy in the government has been charged on the basis of crimes or alleged crimes committed by their employees. So when we see any of these 3 indicators, open criminal types, extensive application of criminal types, or expansion of authorship, we can frame this case as lawfare. The indicators within the criminal procedure are lack of impartiality, political timing of the decision. With lack of impartiality, it could be hidden relations between the judges and the prosecutors, or including the US Embassy, as it happened in the case of Brazil. Abusive or unlawful changes in the institutional bodies in charge of the appointment and removal of magistrates, forum shopping, or transfers of judges and prosecutors without a legal basis. Second, in terms of political timing, we see two possibilities. One is the fast-track procedure. For example, Lula was indicted in 12 months, when this process usually takes longer, or through the use of multiple complaints, so that we can, the lawfare architecture can manage to have some conviction in a certain political moment when it's necessary. For example, Cristina Fernández de Kirchner, the former vice president and president of Argentina, had more than 600 penal complaints against her. Or Correa 52, Lula 25. So with having this amount of complaints, it's possible to manage the political timing of the decision, to have at least one of them having a crucial decision or judgment in a politically sensible moment. The other 2 of the 4 criminal procedure indicators are the use of unconstitutional or unjustified invasive measures, and, for example, wiretapping or pre-trial detention without a legal basis. And finally, the use of lawfully problematic evidence, for example, crown witnesses, illegal evidence, or inconsistent and non-solid one. For example, the use of photocopies of evidence that might have proved that someone had committed a crime related to corruption. And finally, now to conclude, there are also 5 indicators that we could assess in terms of the involvement of the media and social media. First, presenting the accused as guilty already. Just to give you a few titles that appeared in the New York Times, we can see Cristina Kirchner guiltier and more cowardly than ever, or Dilma and Lula knew everything. Second, how the media and social media can escalate the situation, transforming a criminal complaint without sentencing into a moral panic. For example, they stole a whole GDP. Unlawfully filtrating secret information. For example, Sergio Moro handed over to the mainstream media a private conversation. Fourth, disseminations of fake news. And five, the use of trolls and robot accounts in order to create a massive amount of information in social media targeting certain political leader. For example, in the case of Cristina Fernández de Kirchner, one research showed that in one of the criminal cases, 80% of all the comments that were targeting her as a corrupt were indeed trolls. So they were not real people giving their opinions, but they were trolls. So altogether, I wanted to share only these brief reflections, a conceptualization from the South that builds upon a term from the North, but gives it another connotation. And now we are facing the reality of the US debate with lawfare used to describe problems within domestic politics that might be more related with the connotation that we gave to lawfare from Latin America, from the Global South. All the questions that remain open and that we still need to answer through research. And this idea that we might think through these indicators and develop them further to actually assess whether we are facing a legitimate case where corruption, which is a problem within traditional liberal democracies, is being faced, or if we are actually confronting a lawfare case. These indicators have been thought for the Latin American region, but for sure they can be further developed and applied to other regions and even to other historical contexts. Thank you.
Well, thank you very much, Valeria. Off to a blazing start. We could spend the entire 2 hours discussing the various ideas and categories you set out for us. Next up is our representative from Denmark, Mark. It's all yours.
Yeah, thank you so much, Marcus, for hosting this, and Valeria for opening the ball with a lot of really deep and nitty-gritty stuff about Latin America. I'm just going to try to take a little step back. I do have a little bit of visuals here to share as well. So cheekily, I've titled my presentation here, "What is lawfare and why should we care?" I think a lot of us, we're going to be talking about lawfare it's obvious that there is a lot of fuzzy terminology and definitions, and that's why it's great that Valeria is really trying to clean up in this. We're attempting to do somewhat a little bit the same. But let me start with the why should we care, actually. I think, because it's going to be at the heart of my presentation, one reason why we should care is because this is something that's growing in popularity. So if we look at something like lawfare in printed sources, for example, we see that there is very much an increase. It's being used more and more, and it's being used more in comparison with similar terms like judicialization or abusive constitutionalism and even illegal mobilization. So people are writing about this, which means that maybe it's something we should have on our radar, to at least have some clear concepts. People are also Googling this, and I think Tyler might be talking much more about that because there are some specific reasons why people are Googling this. It's mostly in Argentina, it's Brazil, it's Uruguay, and it's the US where people are Googling it the most. I suspect that some of my colleagues here are going to have something to say about that, but it really shows that before around 2009, nobody is Googling this. Literally, 0 people are Googling this. And now we're seeing it much more. So people are writing about this, people are searching for this, and one of the top searches is ¿Qué es lawfare? What is lawfare in Spanish as well? So obviously this is a concern among the public and in society, and I think that's also why we should make it a concern in academia to at least try to explore this term and what it can do for us. And the reason why I think we should do that actually comes from social theorist Anthony Giddens, where he says that, the theories and the stuff that we do in academia and what goes on in society can't be kept separate. I mean, there is a double hermeneutic, he calls it, or a mutual interpretive interplay between academia and society, where things are moving from one sphere to another. We might consider something like discourse, which used to be a very sort of specific academic term, but now is used very widely. And other things also go the other way. And I would suggest that lawfare is one of those terms that, of course, it goes back to Charles Dunlap, and some people had been writing a little bit about this in a purely military context, but it's the popularity in society of lawfare that's driving why we as academics are interested in the term. It's because this is being used more and more, and so it's on us to figure out what this might mean for academic studies. And it also means that the practical implications, how people use lawfare, whether they use it, as Valeria says, in do they use it in a pejorative way? Can we de-ideologize it, as you said? Can we also term things that are legitimate lawfare? I think that this theoretical understanding is intertwined with the practical application of lawfare, and that's why we need to be very attentive to this interplay between how it's used and how we study it, and if we use it in our studies. The same thing with the legal anthropologist Clifford Geertz, who also has these concepts where he talks about something can be experienced near and something can be experienced far. Experienced near, somebody might say that person is a criminal. That's a very experienced near concept of understanding it. Trump might say lock her up. That's a very experienced near way of framing it. An experienced distant concept would be to say this person has been convicted of 2 minor misdemeanors. That's a very, very much a different way of talking about things. And lawfare sort of straddles the two. Is it a legitimate practice, or is it something that you only accuse your opponents of? I know, for example, that in Argentina, the Kirchner has both been accused of performing lawfare, but also says, or there's been studied that she's a victim of lawfare. So these things can sort of travel a little bit, and who the actor, the political and social actor using the concept might mean something different with it than when we write about it in academic papers, for example. And Geertz has this great quote where he says, well, think about love. Love is a very experienced near concept, but something like object catexis is very experienced distant. Lawfare is very experienced near for a lot of people. It's very immediate to understand what it is. Okay, it's trying to get something through law. And that's why a lot of pundits and commentators, journalists and actors in society at large are using it. Our strategy with me and my co-author for our book on lawfare was to say, okay, let's then try to look at the ways in which this is used and then go backwards from there. And what we have is sort of a very broad definition that we call there are different dimensions of lawfare. So we both identify domestic lawfare, which is what I think we're going to be talking most about today, which is this attempting to undermine political adversaries using courts, packing it. But there can also, at least in our minds, be many other kinds of lawfare. For example, we see sanctions as a way of geopolitical lawfare, different ways in which macro-political actors globally can also make use of the law to obtain political objectives. State lawfare, we've analyzed this a lot in territorial conflicts, most notably perhaps with the Basque Country in Catalonia in Spain, or with the conflict in Northern Ireland in the 80s, where we also see legal means or legal instruments being used to obtain political objectives. And then what we would call asymmetric lawfare, which my colleague Siri Gloppen has also developed with red-green lawfare, where you also see bottom-up lawfare. The Komarovs call it the weapons of the weak, or NGOs, for example, suing oil companies, and in this way also trying to do legal mobilization. So we understand this very, very broadly as a concept, and it can cover a lot of different ways in which political actors are using law-based instruments, and this is again to be stood broadly, to obtain political objectives, and it goes way beyond the original military dimension of it. So what I think is very, very important, or the key questions is who is applying this, who's the actor driving this, in what context are they moving this? Is it a domestic context, an international context? Is it an asymmetric power context? What is context for it? And which political objectives lies behind it? So what are the strategies that are being employed by these actors? Is it to accumulate power? Is it to smear political opponents? Is it to defend human rights? Is it to stop oil spilling? Like, this could be very, very heterogeneous. And it is, I think, that when we have this very broad and very actor-centric analysis, I think it helps us a lot in understanding lawfare a lot more. it also, of course, builds on a lot of Foucault's legal governmentality, where justice becomes sort of an instrument of a particular assemblage of power. And I think when you look at the media, you really see all these different ways in which lawfare is spoken about and practiced. So, for example, today I made some small snippets where we can see, Tyler, I had to take all the mentions of lawfare blog out because you guys are very much in the media. So I took lawfare blog out. But when you do, you see that just in the past 2 days, you've had all different kinds of lawfare. So we have some domestic lawfare, or like how the U.S. Congress should curb attacks or users of lawfare. There are pundits talking about how Anglo judges are using lawfare in Hong Kong, the territorial lawfare. Then there's discussion of China using lawfare in territorial grab. This is what I would call geopolitical lawfare. Again, it's a different kind. Then we have Turkish opposition against also being victims of lawfare. This is, again, domestic kind of lawfare. Then we have more with Trump, of course. We also have the EU. The EU Commission is out talking about the use of EU courts or human rights courts to having to decide political issues. That's also, or they at least say that it's a form of lawfare as well. Again, Fox News talks about the Clintons doing lawfare. So again, the same actors can both claim to be victims of it and perpetuate it. And we've also got maybe one of the most recent, which I was talking about, that both my colleague Siri Gloppen and I also work with, which is sort of bottom-up lawfare, or where people are using lawfare for climate concern. So I think that we could see this very, very, very broadly, and at least in our mind, a broad definition with many dimensions does take us some of the way. But hopefully this is something we can discuss further, because when it gets very broad, it also gets somewhat generic, of course. But thank you very much for paying attention.
Oh, thank you very much, Mark, for forcing us to pay attention, because it was such an interesting presentation. And you've already set up our next speaker beautifully. And I want to say, I mean, I think because lawfare is kind of everywhere, nowhere, I think it's very important that we keep in mind the very broad kind of context, as you so beautifully laid out, and you do in your book. I think today the idea is that we try to focus as much as possible on domestic lawfare. So next up is Siri Gloppen, who comes to us from Bergen, the beautiful country of Norway.
Thank you. Thank you for setting this up. It's a wonderful opportunity to discuss something that I think we're all very interested in and concerned about. And I want to just sort of pick up where Mark ended, because you were showing us, Mark, all these examples of allegations of lawfare. And I think that is one, that's an incredibly important phenomenon in itself, the allegations of lawfare. And I think sort of if we sort of Google what is lawfare, we will find that it's sort of defined as misuse of law in courts for strategic reasons. And it's something that we accuse someone else of. So it's the frivolous abuse of domestic law, international law to delegitimize opponents, win public relations with victories, cripple opponents, tie up the opponent's time. And it's all this, but it is sort of an allegation. And that's why we find that each side is sort of throwing allegations of lawfare at another, and that in itself is an important political weapon and an instance, I would argue, of lawfare. In itself. And I think the phenomenon is not new. The phenomenon is very old. And I like to quote, so this is not the term, but I like to quote, you already mentioned the Komarov, and he says that if you go to South Africa, John Komarov, he says, if you go to colonial South Africa in the 18th century, the Tanabe-speaking people, they were talking about the British who were using law courts, papers, contracts, and so on as the English mode of warfare. So this idea that you use the law to get what you want, what you could get by military means or by other ways of force, that you can use the law for the same purpose, is sort of something that is both sort of understood, obviously, for a long time, but also conceptualized a long time ago. And I mean, if you go and look in literature, it starts in the 70s and then it builds up and becomes more and more used in the literature. And I think the reason why it is used in so many different ways is that this strategic use of law for legitimate and illegitimate purposes, depending on your on your vantage point, is something that is really, really integral to politics and to sort of everywhere. And the more central courts and law are to our society, the more sort of legalized our societies become, and the more judicialized our societies become, the broader are the opportunities for using the law for political purposes. But of course, law has always been pros and power, so there is always this element. But I think that is why we're seeing it more. So my perspective has been, okay, so this is an interesting phenomenon, that it is that we have these allegations and that we have this conception of lawfare as misuse of law for strategic reasons. But if we bracket the moral, normative perspective, and we just say, okay, I'm a political scientist, I want to look at it analytically as a political phenomenon, what is it really? And I think, so my argument would be that it is these contentious political contestations where the different sides very often do use different legal means to get to advance their political goals. And I think it's interesting, we can divide it up in different ways, and I think that Marx's division is interesting, but if we keep sort of to the domestic, I think that there are different ways in which we can divide it. And one, I think, is what we're seeing in sort of in the context of what others have called, like Kim Shepler and others have called, autocratic legalism, the use of law, or democratic backsliding, that we use the law for, that the weaponization of the law by autocrats who want to remain in power, that this is one particular context of the law in which we often talk about lawfare. And that's sort of a phenomenon that I think we're all very much concerned about, and where I will talk mainly about. But we also find that in many cases, the same or similar strategies or mirror strategies are used by the democratic opposition. So we have these strategies that are legalized strategies that are used both sort of by those in power, by those who are sort of using them to undermine democratic institutions and democratic processes, and those who are trying to maintain the democratic. And I think it's interesting to just look at it, sort of whether you think they're doing one or the other, just look at what they're doing. And I think we can distinguish between 4 different domains. So one is the strategies that are trying to change the law itself in formal terms. And that would be constitutional or legislative lawfare, where we find, where typically, I mean, I think you find this all over the world. We've studied it in the African context in particular, but if the way you would find, for instance, sort of constitutional changes like lifting of term limits for presidents, tightening of requirements for candidates, or floor crossing clauses that make it easier to sort of tease the opposition to join you. But these type of constitutional regulations that are then sort of lifted in a process where the rules are are being undermined. But this is also a space where that creates a lot of room for the opposition to prevent it, because it takes long. There is a very strict procedures. There's a lot of attention. So this is one space. The other legal domain would be typically laws like public order acts, NGO legislation, media legislation that are also used to cripple the opposition in some cases, but that are also contested. So these would be forms of changing the law through legal means, but sort of undermining the original functioning of the system and the accountability structures in place. And then you could have sort of not really formally changing, but abusing, for instance, about appointment mechanisms, where you could sort of undermine the operation of the institutions by changing the personnel, for instance, in the courts. The second, and this sort of brings us to the second category of lawfare strategies that are exploiting the discretionary space of the law, where and that is particularly taking place within the administrative structures and the bureaucracy. And the bureaucracy is also a sort of it's a space for lawfare that is used both by those in power and by the opposition, trying to sort of get the implementation of the law, tweak the implementation of the law and get it on their hands. And it's used a lot, for instance, by environmental activists, but also, of course, by those who want to prevent it. And then it's the judiciary that, as we heard in Brazil, is being used by the government, and that we find a lot in electoral campaigns, that you keep your opposition in court and so on, but that has both where sort of both sides use this space, and sometimes with success. And then you have, because I see that the time is running up, then you also have the socio-discursive types of lawfare, where you, for instance, allege your opponents of doing illegitimate lawfare. So you have all of these different spaces where different actors are using various mechanisms to weaponize the law. And I think it is useful to keep this analytical perspective as well, not only, and to keep the diagnosis or the tools separate from the diagnosis itself. That we have a tool that can look at different types of weaponization of the law, whether we like it or not, but that we can use to diagnose the dynamics at play and the mechanisms at play.
Well,
So I'll
thank
leave
you.
it at that for now.
Oh, thank you so much. Yeah, what a great start to our conversation. I feel like we have several sets of frameworks now and approaches and possible uses. And I think this notion of the importance of the analytic use of the term, I think that's something I would encourage people to also keep in mind as you kind of launch your discussion. So yeah, the last but not least, I'm delighted that our literature scholar has agreed to join our panel. I mean, it was already fantastically interdisciplinary, but I'm always delighted to have actual interdisciplinary conversations, but also reaching out to the humanities. And so thanks so much for agreeing to join us, Stephanie.
Okay, thanks very much, Marcus, for the invitation. Any opportunity to do anything interdisciplinary is always incredibly welcome. I'm just going to jump straight in then. So in a book chapter published in 2019, I discussed lawfare in the context of Maria Augusta Ramos's 2018 documentary O Processo, The Trial, a film which went behind the scenes with the defense team during the final months of the impeachment of Brazilian President Dilma Rousseff in 2016. And in the chapter, I argued that the documentary serves as a potent illustration of the use of lawfare in contemporary Brazilian politics and of how we can begin to approach Brazil's far-reaching contemporary legal questions from a cultural studies perspective. So it's worth bearing in mind that this is the perspective that I'm using in my thoughts on lawfare in the Brazilian context that I'm sharing today. The definition of lawfare that I used was a very simple one provided by Cristiano Zanin, who at the time was, along with Valeria Martins, ex-President Lula's attorney in the Operation Car Wash. So this is the grafting scandal linked to Petrobras, Brazil's petroleum company. And the very short definition then is the improper use of legal mechanisms as a mean for political persecution. Cristiano Zanin, the term lawfare, and Lula's defence in the Operation Car Wash are all very bound up with each other. And most of the literature discusses lawfare in relation to Lula. But I interpreted lawfare at the time as key to understanding another trial, the one at the heart of the parliamentary coup that ousted Dilma Rousseff from the presidency in 2016. So I'd like to speak to this moment briefly and then reflect a little on the life cycle of the term lawfare in Brazil since then. The process of impeaching President Dilma Rousseff formally began on the 2nd of December 2015, the date Eduardo Cunha, then president of Brazil's lower house, the Chamber of Deputies, accepted an impeachment request, and it ended with a Senate vote on the 31st of August 2016. So the process thus lasted 9 months in total, during which time it completely dominated political life and the news in Brazil, and brought about a period of stagnation in terms of political and social policy development. Hau was filmed behind the scenes in the Senate committee chamber and with Dilma's impeachment defence team as they prepared for the Senate vote. And during this time, Rousseff had been suspended from office for 180 days, with her vice, Michel Temer, acting as interim president. The notional grounds for impeaching President Rousseff were as a result of perceived crimes of fiscal responsibility, and specifically pedaladas, or fiscal peddling, in her administration. The Rousseff administration's budgeting allegedly used these so-called pedaladas to improve its fiscal outcomes and make the surplus for the years 2012 to 2014 appear larger. Notwithstanding the fact that such manoeuvres are, like calls for presidential impeachments, very common in Brazilian politics, what becomes clear in the footage of her trial is that her culpability or otherwise is of little importance. And what we witness is a kangaroo court in action, but one for which the defence team is still expected to spend a large amount of time and resources in the ultimately pointless preparation of countering claims of illegality. So just to give a very brief illustration of this context, one of the authors of the impeachment demand, Janaína Pascoal, stated to Senate, and this is captured in the film, that the impeachment was about much more than accounting issues. For her, it was all about the corruption of the Workers' Party. If it was just about accounting issues, then yes, it would be a parliamentary coup. But it, of course, was precisely and exclusively Rousseff's accounting that was on trial. So in Pascoal's public confession, and from the way the mainstream media reported on the impeachment process, where they very rarely referred to the legal process and instead focused on Rousseff's failure to sort out the Brazilian economy, we can see an example of lawfare in action. 2 years later, in May 2018, the Folha de São Paulo newspaper, the film critic for the Folha de São Paulo, in his review of the trial, he followed a very similar line. The brief review bizarrely includes a subsection entitled, "Where are the Workers' Party politicians linked to the trial now?" in which the references are made to accusations, none proven, and all have since been formally dismissed by the courts against the politicians, including himself, of financial improprieties. The film review then provides further illustration, on this occasion emanating from Brazil's all-powerful print media, of the use of lawfare to maintain an image in the minds of readers of the corruption being innate to the Workers' Party. What Rojadiuk and Bell, in a global context, have referred to as legal harassment of the left, by drawing attention to the kinds of accusations that are regularly made and most often dismissed against Brazilian lawmakers, regardless of party. As Lula's lawyers have argued, the media is a potent means of creating the conditions for the acceptance and legitimation of legal persecution inherent to lawfare. It stimulates a climate of presumption of culpability of a given enemy. The term lawfare was discussed in detail by legal expert Rubens Casada, who describes it as increasing its increasing use as a result of a desire to keep up appearances of democratic normality. It is easier nowadays, he argues, to eliminate political adversaries using the justice system and maintaining a veneer of legitimacy. Thus, what is implied in the term, which like impeachment is used in its English rendering in Brazil, is not necessarily a disregard for the law per se, but a strategic use of existing judicial processes, and specifically to defeat a political adversary. As I see it, it can also imply taking advantage of the complexity of Brazilian law and reflecting on the seemingly random way it is applied. So why are some laws applied in certain situations and others are not? Why are some lawsuits archived and others are handled with uncanny speed, as Valeria described earlier? Casada argues that understanding lawfare and rejecting the myth of the neutrality of the justice system are fundamental for any democratic project. So this strikes me at being at odds with what Cristiano Zanin has to say about lawfare now that he has been appointed to the Supreme Court in Brazil. When asked how a Supreme Court minister could combat lawfare by a journalist, Zanin's emphatic reply was, "O magistrado não deve combater nada. A judge shouldn't be combating anything." In his view, the role of the Supreme Court is to guarantee the application of the Constitution, which only directly would mean combating warfare. Lula and warfare are the reasons why Zanin is now a Supreme Court minister. Lula, because he was nominated by him and because of the high-profile body of work he did around defending Lula against corruption charges linked to the Operation Car Wash, which did eventually end in charges being dropped and Lula being able to run again for president. And lawfare, because it was on this basis that Zanin could claim remarkable legal knowledge, which together with unblemished reputation are supposedly the cornerstones of appointments to the Supreme Court in Brazil. Together with Valesca Martins and Rafael Valim, Zanin has sought to capitalise, or he sought back in 2017 to capitalise on the potential of the term lawfare to help argue for Lula's release by setting up the Lawfare Institute. An English language website, it purports to offer an opportunity for visitors to the site to denounce instances of lawfare across the world. Although the website has been up and running for some time, I could find no trace of the reported regular publications of the group, such as the weekly The Lawfare Journal. I found an image of issue 1, but not the issue itself. It does list the monograph on warfare that Zanin, Martins and Valim published, first in Portuguese in 2019, then in Spanish, and most recently in English. And the title in English is Lawfare, Waging War Through Law, published by Routledge. Google searches of the Lawfare Institute bring up the US-based Lawfare website, sponsored by Brookings think tank. While there is no link between the Brazilian and the US Lawfare websites, there is also seemingly no effort made to avoid confusion, with at least one Brazilian news article reporting that the Brazilian website was sponsored by Brookings. So just to finish off this brief intervention, me being the complete cynic that I am, I do wonder about the shelf life of the term lawfare in the Brazilian context, if its citation by Zanin was in fact a means to an end, so freedom for Lula and a coveted place in the Supreme Court. What will be interesting to see is if Bolsonaro and the right are able or willing to wrestle the term from the left, as Trump and his followers have done in the US. Thank you.
Thank you very much, Stephanie, and all your fellow panel one panelists. It's a lot to think about, lots to talk about. So I'm not an expert, so I'm going to leave the floor to the experts, and I encourage you to ask each other questions, challenge each other, or agree with each other. But it seems like there's a lot of stuff that you guys agree and both and disagree on to get a conversation going. Rocío, looks like you're the first.
Yes, so I don't want to say too much because I'm going to say something more when it's my turn, but I'm wondering, and probably this question goes to, well, to everyone, but maybe I can't see, yeah, to Stephanie. So my husband was the editor of a documentary about the Brazilian Dilma that's called The Edge of Democracy, that was done by Petra Costa. And while he was shooting this, they were shooting, it took like 2 years because they were shooting for the Dilma situation. But then while they were shooting, Lula went to prison, Bolsonaro got elected. So it was like all, and I remember their view was this view of Lawfare. And I was, as a lawyer, always surprised about the institutional design of Brazilian Supreme Court and institutions. And I kept wondering, is this a problem of Lawfare, or is just like, you need to design better your institutions? Same thing with American Supreme Court. So I wonder whether this is just, some institutional design that allows the political to enter more than the necessary into the legal field. Or is it like something really that's a contemporary historical event that's new and that we can't tackle with just through the law itself in a way? So this is a question to everyone, really, or just a thought. Thanks.
Well, I can't speak to the to the legal response to that particular question, but I mean, I am struck by something that Siri mentioned, which was the discretionary space of the law. And had I had more time to think that through, I probably could have worked that in. If I had known about it, I could have worked that into my mini presentation. I think that's precisely that. The impression that I have from the reading that I've done to be able to write about, sort of this from a cultural studies perspective, is that it's precisely those discretionary spaces that people are tending to take advantage of. I mean, the film that you mentioned is really interesting. And there were actually 4 films that came out, 4 documentaries that came out on that same subject, all within the space of 3 years of each other, 3 made by women, 1 by a man. So it was something that I think it was a moment that was unique. Again, from a cultural studies perspective, just thinking of it from that perspective, it was quite unique. Were you to pick it apart and ask, well, is this something that's happened before? Certainly there was an impeachment case, of course, back in 1990. So it's not, so in the post-democracy period, post 1989, it's not necessarily that unusual. But yeah, I mean, I'm thinking it was, it was that sense of taking advantage of the spaces that presumably the law enables people to take advantage of, but having a necessary body of weight behind the lawmakers to be able to go with that. Gilma was incredibly unpopular. At the height of her presidency when this all broke. So
I don't want to get involved, but I saw that, Manuel, you had your hand up. Was that in response to Rocío's question, or was it a separate point?
A separate point, but after Stephanie, it isn't so separate, because as a criminal lawyer, I wanted to take up what Valeria said and also what Siri said, because I think we have to think also of what characteristics has the draft of the written criminal law, which is central in any of our systems. And my opinion, to say it in one sentence, would be, of course, lawfare is practiced enemy criminal law. Because if you have a drafting of your criminal offenses that would restrict, together with an interpretation culture, possibilities of interpretation to abuse criminal law, then the space for lawfare is reduced. If you have enemy criminal law, it is designed to open up any possibility and to find your enemy. You don't need to describe what he does, but who he is. So I would say there is an intense relationship. Any law has a discretionary space. Any lawyer knows that. You have to interpret everything, otherwise we wouldn't be earning our living. But the thing is, there is a special kind of law, not only institutional system. I thought the same as Rocío said, but there is a criminal law specially designed for lawfare. And we should, I know it's not much, it's not too popular, but we need also analytic tools for the lawfare area, which are specific technically legal analysis.
Siri, yeah, do you want to continue?
Yes, I want to just follow up on the same. So it's so because I think it's a very interesting question, and I do think, I mean, like more or less what Manuel says. I mean, there is this. So the term may be new, but there is this old saying that for my friends anything, for my enemies the law, which also has this. It also shows in a way that whether to apply the law or not is always discretionary, and how you apply it and when you apply it. And I mean, what we see a lot in many contexts, including in many African cases, is that, I mean, corruption is super interesting. There is always corruption. So, and everybody's more or less corrupt. And you can sort of, but who is prosecuted and when they're prosecuted is not random. There is a lot of power behind that. And I think that this I don't think that you can do, I agree that you can do something. Some types of law are more prone to misuse if you want, but there will always be a discretionary space that can be abused or that can be used for your purpose, for good or bad. And I think that that is how it is. And I think we need to, if you think about sort of there are always sort of informal norms that are underlaying, if you want, formal regulations. I mean, this is something that many scholars have started paying more attention to and talking about in different ways. But I mean, no legal norms are sufficient in themselves. And if they are underpinned by social norms that uphold them, then they work in the way that they maybe were intended. But if you sort of change the norms underneath, the law becomes fragile. So then whether it's at the constitutional level, and I think that is what many people are worried about in US politics, that suddenly the rules are not legal. They don't mean the same that they did anymore. And it's very difficult to sort of to retract it. But I think that this knowledge that there are all of these informal norms that are also there and that are sort of deciding how we interpret the formal norms, it's there anyway. So I don't think we can get rid of lawfare. But I do think that this point about what is the sell-by date or what's the lifespan of the term, I think the term is overused and it's something that is now more or less just an accusation in many contexts, and we're going to find a different term for analytical purposes in a while, but the phenomenon is going to be there, and I think that's why it's important to try and sort of get the phenomenon.
Mark, please go ahead.
Yeah, no, I was just waiting for the go ahead. Yeah, I just wanted to build on some of these points raised by Manuel and Siri as well. So I'm just going to call it domestic lawfare to stay in my own analytical vocabulary. But I do think it's interesting that when we talk about sort of discretionary space and that there is always something in law. So in my book, at least, I looked at it a little bit like if you look at an authoritarian regime, lawfare in a way doesn't exist or is endemic, either of the two. There is either it is completely endemic or intrinsic to the system, or we can't call it lawfare because it's not in any way it's not an anomaly in that system. In a liberal democratic system, I say it's more of an anomaly that political opponents use this I should say, Siri, sort of exploiting issues of the law, or undermining like that is, I think it's a feature almost in liberal democratic states more than in authoritarian governments, where we this space is in a way too wide and too narrow. So I think it's very interesting to discuss when there is legal interpretation. As Siri said, so sort of for my enemies, the law, if you have a system where abuse is simply use, then you also, in a way, wouldn't have lawfare. Or I at least wouldn't see it as lawfare. I would simply see it as authoritarianism.
And I just comment on that. I think that's very interesting. And I think it's certainly true in some contexts, but I think that there are also, I mean, you can have a system that has a level of rule of law, even if it's not liberal and even if it's not democratic. That's a continuum. So I don't think that I mean, if you look at a country like Malawi, it had a relatively high level of rule of law, even at certain aspects of rule of law, were relatively sound, even in a very authoritarian system. So I think that's which also enables the use of law. I mean, would you find that in many cases that even if the government is not particularly democratic or liberal, you can use the law the opposition can use the law for quite a lot of purposes. So I think it's important to not sort of conflate it, because there's definitely something there, and there are definitely cases where the law doesn't have a meaning, but I think that there are many cases in which the law does have a certain meaning, even if it's not a liberal democracy.
Yeah, I mean, as a non-expert on lawfare, I was very excited about the lawfare, the discovery of lawfare. Again, going back to Valeria's contribution and brilliant article, I was excited because I thought, wow, this is great. There's a South American, global South generated project concept framework. And then I very quickly found out, well, it's a lot more complicated than that. And then I realized, oh, actually, it's the English term that is being used. Which kind of a comparative comment and also invitation to you, Valeria, given that, you also are connected to Germany. I mean, in Germany, one of the funny things about the German criminal law system was that they insisted they had no plea bargaining. And when they started to talk about plea bargaining, they insisted on using the English term. And the person who exposed the practice of plea bargaining used the pseudonym Detlef Deal. So the fact that the word was never translated into German and then they try to deal with it now, but they it's a hot potato. It's a foreign substance that. But clearly, that's not what's going on with lawfare. So I'm kind of curious, about this aspect, the fact that this is English, not just the kind of origin, but also English term. But then also perhaps to invite you, and I don't know if you've thought about this, but the absence of lawfare in the German conversation, by and large. I mean, of the use of the term. So is Germany going to be the next frontier? It's made its way into the US. How have the Germans so far resisted the temptation of speaking in terms of lawfare?
I am doubtful if maybe, like, they haven't raised the point yet, but if Alternative for Deutschland, the right-wing extremist party in Germany, at some point will build upon this lawfare concept to defend themselves, because they are the only party that is a little bit disrupting how German politics, and you will know this better than me, usually plays, that is through consensus. So the main difference between Germany and other countries in Europe, but particularly to the US and Latin America, is that here there is always this priority to put everything through dialogue and arrive to consensus, even for parties that are very polarized in the political spectrum. And you get to have a common government with the liberals, the Greens, the Social Democrats. That would be like a dream coming true for any Latin American parliament where we cannot even agree on certain politics. And in terms of what you were saying about the term, I think like maybe the others will be able to contribute better than I, but in Brazil, it's not so weird to use English terms. In Germany either, when we are in the conferences on criminal law and criminology, it's repeatedly that we use punitivity, Plibergen, and many words, they come up all the time. But in Spain and in Argentina, we are more concerned about like really preserving our own terms. And there was a lot of reluctancy to use the term lawfare. Even with the co-authors of the book that I wrote that has as a title Lawfare, but in the beginning they were like, why are we using an English word? And then we started talking if it should be soft words or judicial words or words that use the law. And none of them were really satisfying. And that's how I ended up thinking that maybe we can use this concept of golpe por goteo or dripping cup, because the idea is to take someone out of the political arena. And in Latin America, this has a violent history that it has been done traditionally through coup d'etats, where there was a military intervention and the person was actually out of the political scene. And now the lawfare comes a little bit to play this game, and without using the military, they managed to achieve the same results of having someone out of power through this continued dropping of accusations of corruption until the person is completely delegitimized or even legally barred from participating in politics. Just to close this intervention, I want to ask a question to all of you that I have been thinking from this morning. I don't know if you're aware that now the political situation in Argentina is just absolutely depressing, with a person that thinks that the goal is to implement anarcho-capitalism in the country and sell everything, open the economy, privatize all the corporations. And right now, lawfare is not a main topic in the political media agenda anymore in Argentina. So I was wondering, what do you think? Could it be that when the government is within the limits of liberal democracy, but it's a right-wing extremist government that is really willing to follow the agenda of the main corporations and the people that hold the real power, so to say, that there is no real opposition that is confronting this agenda, then lawfare is not actually needed? Because it really changes from the prior government, that it was right-wing, that it was the government led by Macri, that it was more similar to the Bolsonaro government, so a government that is against social justice, but that still is protective of the national economy and is confronted with the economic power, and having this other person that is really not following a protective agenda, not caring about the actual development of the domestic industry, and where lawfare doesn't seem to be in the agenda anymore.
Yeah, thank you so much. That's a depressing question, because just as we're hosting this event to announce the spread of lawfare all over the world, now it turns out it's already outlived its shelf life, to quote Siri. So we have just a couple of minutes to finish up the discussion, then move on to the next panel. But so I want to invite Siri and Mark to kind of take us home.
So I just wanted to say a couple of things. A lot of very, very interesting points raised. And I think that there is something in what Valeria said that we need to explore more. But I think that there is something about sort of proportional representation, political systems that are more consensus-oriented, where I think you generally have less lawfare. So this is just something that we need to explore it more, but I think there is something there. It's the way the political systems function. Because you often all have less in the more sort of checks and balances type of systems. The courts are much more central to the political system as well. So I think there is something about the parliamentarian systems, but also the proportional representation systems where you have more coalition governments and so on. So I think that's important. I think the term, it's just very difficult to translate, because the term lawfare feeds off warfare. And it's in most languages, it's just difficult to get that. So I think that's also what makes it catchy. But I was just remembering that we had a project that started about 10 years ago, which we called abortion lawfare in Latin America, because then we were looking at how different sides were using the law. And then I know that many people said, we can't use the term because in Latin America, it's just used to discredit NGOs and civil society on the left. So the whole use of the term has also changed. So I just wanted to sort of put that out there, that it's different. But yeah, but thank you so much for a wonderful discussion.
Yeah,
Thank
I
you.
just wanted to piggyback on that. That I really like that it, of course, it feeds on warfare, and you hear it once and you remember it surely. But I also do think that it's interesting that it's flexible. So if you look at something like this asymmetric lawfare, how NGOs are making use of lawfare as well in domestic. I mean, there it's not necessarily with the same power asymmetry that what we're talking about now. For example, I also interesting. And we have this with the language and lawfare. Because I study a Spanish context, I saw it first among the Catalan minority who felt they were victims of lawfare. And now I see it being much more adopted by El País and mainstream media because it's directed towards Pedro Sanchez, which Manuel, I'm sure you'll talk much more about. So maybe there's also a little bit where it has to really seep into a sort of a collective psyche and become a term. And as you say, Siri, it's very difficult to translate, but now we're all walking around saying lawfare. And even digitalization would be difficult to translate into Danish. I mean, I would call that a retsliggørelse, which also isn't very sort of easy to throw around. So it is just a very interesting, malleable, flexible concept that's very fruitful to talk about, and really nice to be part of that.
Well, this is, I mean, the best segue imaginable. So moving on to the next panel, and it just so happens that the first member of our next panel is Manuel Cancio Meliá. So, Manuel, it's all yours.
Well, it is indeed very interesting. You know, when you spend your university life hearing about interdisciplinary work, and this is only on paper, when you see that people that study other disciplines have things to teach you. So it's very interesting. Thank you, Marcus, for setting this up. So I think my feeling was from the beginning, I should talk about Spain. I'm no expert in lawfare, of course not. But I think it's very interesting from a theoretic point of view, especially relating to some theory developments in the last decades in substantial criminal law. But I think it's better I try to, in these 10 minutes, to try to make you visible what is happening in Spain. Because in my way, it's let's say, of course, we are Latin American. I'm an American, Latin American too, because I was born in Mexico. But it's really interesting to see how Brazil is driving to us. I never would have thought that when I was reading about Dilma and the process against Lula, that we would be in a similar place. And I'm sorry to say, we are. Lawfare has started in Spain in the last years, very recently. And it's related, as Mark said before, especially to the Catalan issue. But before this, and I would agree with Siri, of course, it has always existed. And there are different political systems that are more or less prone to this use of the criminal justice system. But the term that was used in Spanish, or in Spain at least, was that of judicialization of politics or politicization of criminal justice. And lawfare has emerged in the last 10 years, I would say. So, as to the case in Spain, first we have to see that Spain is, of course, a member of the European Union and a normal liberal democracy relates to its constitution, to fundamental rights, and so on. But this regime was born out of a dictatorship that has no match in the Western world. 40 years of national Catholic military dictatorship, and there wasn't any revolution, or there wasn't just dropping out of the regime as in Portugal, but there was a negotiation, and the famous transición, which was transition, which was sacralized as a model of peaceful regime change, now, from 40 perspectives later, shows that there had to be things to be negotiated with the representatives of the dictatorship. And this is crucial also in this respect of the use of criminal justice for political means, in this domestic lawfare, as Mark would say. First, there was a transition with the army, especially after the coup of 1981, but there was never no change in the structures of the criminal law system, of judges, and no judge was expelled from his or her condition for having killed people in fake trials, for instance, in the last days of the dictatorship. No minister was prosecuted for signing these death sentences, which were obviously criminal in itself. So the justice system in Spain wasn't reformed. Of course, many years have gone by, but I would say this, you can see it now, in that there is a selection system, a selection method that favors nepotism, close shop, judge, or prosecutors' families. Spanish judges are very, very right-wing, and this stems from no real new building of this system. And then there is another element that makes criminal justice very important in the political area, which is that there are a series of special jurisdictions which are located for parliamentarians or for the members of government with the criminal chamber of the Supreme Court. So if you commit any crime being a member of the government, you have to be judged by these 15 people of the criminal chamber of the Supreme Court. And of course, the selection of these judges is controlled by political parties, because they know these are my judges, not the judge that will be competent for the territory. So now, in this context, I have to add too that traditional mass media are have the same structure more or less than decades ago, and are mostly right-wing oriented, very strongly so. So, coming to the lawfare that we had in the last years, as many of you will know, Spain has a territorial problem since about 150 years. There is a strong movement, not strong enough to have a two-thirds majority, a Canadian majority. But there are zones where many Catalans and Basques, especially Galicians, some Galicians too, want to separation from Spain. They don't feel Spanish. They don't want to be part of this state. And this has led to two fields in Spanish politics. On one hand, we have Spanish left-wing or center left-wing parties. And on the other side, we have peripheral nationalists, That's how they called them, how they are called in Spain. This means Basque and Spanish nationalists, because nobody refers in the Spanish press to Spanish nationalists as nationalists, of course, they're just Spanish. So what has happened in the last years is that we have had a constant abuse of criminal law in which is related with Euskaditas Katasuna, with ETA, the Basque criminal organization. I can go into it, but there was very often the use of criminal law, of poorly drafted criminal law, to let's say, prosecute people in the surroundings of ETA, many times very far away from it. So that 5 years ago, a person was convicted for glorification of terrorism because she had made a joke about the killing of the Spanish prime minister in 1973. He was the prime minister of the Spanish dictatorship. So for 12 jokes, he was flying into the air because ETA put a bomb under his car. She was convicted for glorification of terrorism. We could convict Georg Eisner for putting this bomb into the Bürgerbräu in Munich in 1941. It tried to kill Hitler, but it didn't happen. So this would have been terrorist for the Spanish Supreme Court. After this, the conflict with Catalonia has been rising steadily from a more or less peaceful situation with tensions, but no conflict, from the year 2010. And from the beginning, it was a conflict that was fueled by Spanish courts, because the conflict started because the Spanish Constitutional Court deemed inappropriate, unconstitutional, to speak of a Catalan nation in a text that was in a legal constitution of Catalonia. It's not called constitution, but statute that had been approved by Spanish Parliament, by the Catalan Parliament, and ratified in referendum. The majority of the Constitutional Court, right wing, of course, thought it appropriate to say, no, you have to get this word nation out of your text, even against all this strong democratic legitimation. And then it went up and up and up. The crisis, the subprime crisis, which hit Spain very strongly, made the Catalan nationalists, right wing, to go to the streets, because otherwise they would have lost any power. So we had in 2017 this illegal referendum and the repression by the Spanish police forces. And in 2019, a very harsh sentence, up to 13 years, for organizing this referendum. As a reaction to this sentence, there was some street trouble in 2019. Nobody got killed. Nobody really, there wasn't the use of arms and so on, but there were riots on the streets. And now, 2024, and I'm coming to my end, the current center-left government of Spanish parties and peripheral nationalists has voted with the majority of the Spanish parliament an amnesty. And then really open lawfare has started. We have had, by a central investigating judge, because this is one of the issues in Spain, anybody can accuse anybody for a public crime. This is the so-called popular accusation. So an investigating judge just has to wait. You just have to wait until the investigating judge is on duty, and then you present your complaint. And if he's the right judge, he will take it up and start a proceeding. So Valeria said it with a perfect timing when the Amnesty Act was going to be approved by Parliament, such a central investigating judge, which is very strongly related to the political party of the riot, started an investigation for terrorism crimes in 2019. 5 years later. 5 years later, he started this investigation and held Carles Puigdemont, the former president of the Catalan government, as a possible suspect of a terrorist murder, because this isn't a joke. Yes? Because a French citizen had a heart attack at the airport of Barcelona at the time where it was surrounded by riots. He wasn't hit by nobody, but he had a heart attack, and this investigating judge and the Supreme Court of Spain have said, okay, let's investigate this heart attack. Perhaps it's a terroristic heart attack, and it's no joke. And the last thing we have had is that there is a very strange, very strange criminal investigation by another investigating judge that takes up a criminal complaint filed by the fascist party, the Spanish fascist party. I think our right-wing party, extreme right-wing, they're fascists. You can use this term without any problem. So this complaint was filed. The public prosecutor won't take it up against the wife of the prime minister. Investigation started a few weeks ago. Up to the moment, in all the loudspeakers of the media, of the mass media of the right, there isn't, up to this moment, anything to investigate. That's my technical opinion. And the use 2 or 3 days before the elections to the European Parliament is very, very clear. I have to stop here. I just would recommend to our German, even to our Swiss partners and friends, do not think that lawfare is not possible in Europe. At least in the southwestern corner, it is.
Well, thank you very much, Manuel, for this sobering contribution, which at the same time, however, gives us hope that perhaps lawfare will be something to be discussed for many years to come. So next up, Rocío, thank you so much for joining us. And again, I'm so glad that electricity is working properly, and welcome from Chile. So it's all yours.
Thank you. Okay, so as I said before, I'm not an expert at all in lawfare, and I'm quite skeptic about the convenience of using the term. So what I'm going to try to do now in these minutes is just to kind of try to understand why should we consider using this category as distinct to explain, the usual phenomena of law and power and idealization of politics, etc. So the reason why I'm skeptic about the idea of lawfare is because of how it's been used, and particularly of how it started being used, right? So in the context of war, it seemed to me that lawfare was, as an accusation, a tactic strategy of a party to avoid or to deflect attention on their own responsibility. So let's not talk about the law, let's see how the law is being used strategically. And I thought this wasn't fair, because let's talk about the law. If it's being used strategically, who cares? If you're breaking the law, we should take a look at it. So even if it's used in cases in which complying with the law, it's being made extremely hard by the one that's practicing lawfare, well, the law has defenses you can use in those cases. So it seemed to me that as a legal argument, it presented a false dilemma that was used by the party who didn't want legal attention over their own breaches of law. And I thought law has enough categories and abilities to deal with these situations and to consider it, consider context, etc. And also, I think, well, liberal law is not the same as morality. It doesn't matter in law the reasons why you use the law, the reasons why you fulfill your legal duties. What matters is that you fulfill your legal duties, and you can use the law as much as you want for any reason, as long as you don't damage other people's rights. And this is better than just power, because in law you have a standard, a general standard, you have institutions, etc. But of course, so that's a first thing. If lawfare is just about exploiting the law and using it instrumentally, I think it's dangerous to see a problem there. And it's just not right, because the liberal law does not expect you not to instrumentalize it in a way. So the other, I guess, the perspective to see lawfare, which is more connected to what we've been talking here, it's lawfare as a particular way in which law and politics meet, right? Because we all know politics and law meet all the time. Law is power, but it's not the same as power. It's a little better than power, because there are some limits and there's some guarantees that, you know, would distinguish whatever happens in law from just naked power, right? And so when it comes to the politicization of justice, so the Latin America, and I think also the US and even Europe, has seen different ways in which the judiciary, and well, I guess all the world, I don't even think it's necessary to make any geographical distinctions here, right? The law is used by the political system in different ways. So everywhere we have the activist judge that will sometimes use constitutional law or international law to alter the normative landscape of a community in ways that could seem that go against the democratic division of powers logic. We also have activist judge that will regulate areas that are not regulated. And we have that a lot in countries like Chile, where because we have a presidential system, we often have a situation in which the legislature cannot legislate, because we have a presidential system, and we also have not a representative system. So we usually have two big forces, more like the US, political forces, and the president. And often the president does not have majority in parliament. It only has majority in parliament the first year, usually. By the second year, someone from their party has gone to the other side. And so they basically can't pass any laws. And so the judges sometimes have to make decisions that, you know, undercover have general effects and fill up this space. And that brings all kinds of problems. Right now, we have a big issue here because the Supreme Court declared that the private health insurance companies were charging illegally. And so by this judicial decisions, and there were hundreds and thousands of cases, they practically changed the rules of the health system, you know, and this created a very big problem. But it's a kind of problem we don't need to call lawfare anyway. It's just, you know, like a problem of legal design, of political design. At least that's how I see it. And then we have the more kind of a stricto sensu lawfare situation, which is this, I guess we see it a lot in Latin America in the last 10 or 15 years. It's happening now in the US, where you use the law to win a different game through the law, right? So I use the law in order to win the electoral game without playing the electoral game by getting rid of an opponent. And I have a funny case to illustrate this. That's not from the political or from the electoral game, which is in last World Cup, Chile didn't make it to Chile wasn't selected to go to the World Cup, but it almost was. And we were left behind by Ecuador for very little. And a Chilean person discovered that one of the players in the Ecuadorian team was not Ecuadorian, but was actually Colombian. But, you know, he moved to Ecuador when he was like 6 months old, so he was fully Ecuadorian, but he had been born in Colombia, and his mother never did the paperwork in the right way. And so when Ecuador discovered this, they sort of changed his papers very quickly to not have any problems with the World Cup organization, but the Chileans went to the FIFA. Is it called FIFA? Well, you know what the FIFA is, right? And they asked this player to be disqualified and Ecuador to be disqualified so that we could go to the World Cup. And the Chileans were, until a week before the World Cup started, fingers crossed that we would get to the World Cup in this, you know, perfidious way. And we didn't get there. But it was very interesting as an example in a different field, right? We want to win the soccer game in this weird way. And there seems to be something really wrong about that. It makes the soccer game, it damages the soccer game. And I think something similar happens when you use the law to take out a competitor in the electoral game, right? It seems to damage the electoral game, but it doesn't damage the law at all. It's just, you know, the law will operate on its own ways, I think. And so now moving to the case that really matters to us, which is like how lawfare can damage democracy by, you know, using it in this way where you get rid of your opponents. I don't see why we need this a specific way of speaking, and I worry that there are too many risks in the idea of lawfare, because what the idea of lawfare does to me is that it brings a very complicated issue into a very small charge that has a strong rhetorical force, negative rhetorical force, as an accusation. And it can be used both ways. And I see the way that's going to win in this competition of who's doing lawfare is those who want to undermine the legitimacy of legal institutions. And I find that very problematic. So we've been using lawfare in this way all the time in Latin America, during dictatorship, after dictatorship, crimes of sedition. We had a panel on this here not too long ago, right? The law has always been used as a way to get rid of your political opponent. Perhaps now it's used through the trial, which is more spectacular and has more like media coverage. But this is something the law has always done. And I think it's better to avoid this kind of summarizing concept that has rhetorical force to describe the issue so that you can see the issue in context and evaluate it, you know, looking at the merits of the case rather than in this kind of rhetorical way. So that's I guess where I'm at. Like, I'm not sure this is convenient, and I think the Trump case illustrates the risks that we have there. In Chile, we have a lot of these cases now with mayors, because we have a lot of mayors being accused of corruption from all the different political parties. But well, there is a lot of corruption too. So it's like you don't want to create a concept where you know, prosecuting politicians becomes suspicious per se, because we also need to keep our politicians accountable. So that's why I think better not, or I worry that using this kind of keyword will simplify a situation that we need to keep complicated, if that makes sense. Thank you.
Yeah, makes perfect sense to me. I think lawfare is interesting partly because so many people seem so eager to use it. So it doesn't mean maybe we shouldn't use it, but I think it does mean we should be talking about it. And one of the things that I noticed, kind of, you know, putting this together, and was that, and Manuel mentioned this also, there's a lot of talk of lawfare, but there's very little still study of lawfare, you know, conversations like this. I mean, there are great books emerging, and Siri and many others and Valeria have done amazing work, but in a way there isn't enough attention paid to it in this context. So thank you very much. And so now I'd like to shift our attention to Gautam, who I think you're joining us from Delhi, and perhaps you will chime in as much as you like from an Indian perspective, or maybe also you can bring in the Kenyan experience, whatever you'd like to contribute. I'm delighted that you have joined us again. You were also part of the sedition panel, so I feel like it's alums, the sedition alums are coming to reunion in a way. So welcome.
Yeah, thanks. No, I'm going to speak about India because I don't really know much about lawfare in Kenya, other than just the basics. And also, I think that lawfare is right now a pressing concern in India and not so much in Kenya as of this moment. It's also because one doesn't normally think of India when lawfare is mentioned. So you normally think of Latin America, the use of laws to persecute political opponents, weaponization of laws to achieve political goals, and so on. Or you think of, say, a place like Singapore, where defamation laws are used again to silence political opposition. You don't think of India, and there's a certain reputation the Indian courts have, which is not it needs to be questioned a little bit. So I'll just make three points on this. So one is that that lawfare in India is a direct result of the increasing role that is being played by courts, especially the Supreme Court, in Indian public life, in literature, and specifically in literature that is discussed abroad, outside India. This is often written about as a good thing. Yes, the Supreme Court is activist. It gets into these governance deficit issues. It holds people accountable, and so on. And specifically, the point I want to make is that many of the legal mechanisms that people perceive to be great innovations and great things about the Indian courts are directly related to the way in which the courts are being used for lawfare. This includes the unprincipled expansion of the court's jurisdiction over a range of issues, the loosening of standing requirements that allows anyone to file cases before the court, and the weakening of precedent as a constraining force upon the court. A combination of all these means that basically the courts are effectively unaccountable in how they adjudicate cases on a day-by-day basis, which in turn makes them ripe candidates for lawfare. So to give you one example of this, or two examples of this from recent times. So one is that, for example, there was a report called the Hindenburg Report, which accused the major Indian industrialist, also known to be close to the ruling party, of basically of some kind of regulatory malfeasance, and then the short selling of stocks and so on. Soon after that, the petition was filed, and the Supreme Court took cognizance of this on the very specious and spurious basis that the Supreme Court needs to protect Indian investors. No legal basis, no constitutional basis. There was no argument that a shareholder filed a case saying my right has been violated under the Constitution. Nothing. But because there is absolutely no constraint on jurisdiction and standing, this case was filed, and the Supreme Court heard the case. The Supreme Court then set up a committee to investigate this issue. The committee's composition was criticized severely by civil society as being compromised. But of course, because the Supreme Court had set it up, nobody could complain. Most importantly, and this is really the core of the issue, the Supreme Court's taking cognizance of the case meant that the political struggle was hamstrung. So, for example, political parties could not demand a parliamentary investigation into this because the Supreme Court now has taken cognizance. So in that sense, the Supreme Court taking a case disempowers the political domain and the political movements from actually, raising the same issue in other forums. Another example of this was that 2 or 3 years ago, very controversial legislation involving Indian farmers, was passed by Parliament. This led to widespread protests, a year-long protest movement of the farmers that that effectively brought the government to its knees. Then someone challenges these farmers being unconstitutional, and this is also again a part of Indian lawfare is what we call ambush litigation. So basically, the people involved don't want to go to court, but because under Indian law, anyone can go to court under the guise of public interest litigation, someone who is totally unconnected, in fact, in many cases actually set up by the government, goes to court filing a challenge. The idea being that you file a half-baked challenge, which then you either get dismissed or otherwise, the court takes it up, and then other things, the real challenges cannot actually be filed. So in this case, someone unconnected to the farmers' movement filed a very half-baked constitutional challenge to these farm laws. The Supreme Court takes it up and passes a completely unreasoned order staying these laws. At which point the government says, look, the Supreme Court has now stayed these laws. There is no more need for protests. So why don't all the farmers go home? Because now the laws have been stayed. Of course, the farmers were clever enough not to fall for this, and they continued the protest until the laws were taken back. But here again is an example of a very unconventional kind of Indian lawfare, where the complete dilution of jurisdiction and standing and so on effectively makes the court a political weapon, which is then used to delegitimize or otherwise hamstring political movements by judicializing a dispute, even when people don't want it. Those who are affected by it don't want that, but still you judicialize the dispute and therefore cut off the political struggle. So that's been a major way in which Indian lawfare takes place. Very briefly, since I have 2 or 3 minutes left, there is of course the more classic lawfare that happens, and that happens a lot in India as well, the more familiar lawfare. 2 main weapons: anti-corruption laws and terrorism laws. So anti-corruption laws are used to go after political opponents. So we have had multiple opponents of the ruling party jailed under anti-corruption laws because anti-corruption laws effectively make the conditions for bail very stringent. And the courts use that to deny political opponents bail. So the Indian election right now, it just got done. In that, multiple political opponents were jailed under anti-corruption laws without trial. And 2 of these were high-profile people. They were the chief ministers of Delhi and of Indian state Jharkhand, respectively. Again, to just show you just how lawfare takes place, while the Jharkhand chief minister was not given bail and he stayed in jail and is still in jail, the same Supreme Court bench that refused him bail gave interim bail to the Delhi chief minister, saying that because he's a national political figure, he should be allowed to campaign for 20 days in the annual election. Right? No reason as to why the same did not extend to the other chief minister in jail. No reason why he was released after 1 month of the election had already taken place and just 20 days were left. So again, the complete absence of legal reasoning and of precedent as a force in Indian jurisprudence basically allows the Supreme Court to exercise a kind of patronage over personal liberty. So when it wants, it can say, okay, you chief minister of X state, we let you go for 20 days to campaign in the election, but you chief minister of Y state will not get bail. And that again is one of the and the Supreme Court has been in history praised for basically doing complete justice by dispensing with all these procedural requirements, all these pesky criminal procedure provisions, but that you can see actually gives this court this vast power to intervene in the political space in completely unaccountable ways, as this case shows. The other example is that Rahul Gandhi, who was one of the main figures of the opposition, was convicted for criminal defamation by a trial court in the state of Gujarat. Now, in India, criminal defamation rarely takes place. Rarely do you have convictions for it. The upper limit is 2 years imprisonment, and nobody in 70 years has ever gotten that until Rahul Gandhi got that sentence. Now, under Indian law, there is a minimum sentence. If you're given that sentence, you are disqualified from parliament. That is 2 years. So coincidentally, the exact sentence he was given, which is the maximum sentence for criminal defamation, and which is never ever given by Indian courts, also was a sentence that gets you out of parliament. So he is disqualified from parliament. Then he appeals, the High Court affirms that sentence, and the Supreme Court then stays his conviction. And thus he can again get back into parliament. But again, there's no reason given for that. Just there is a one-line stay order Supreme Court gives that we are staying the conviction and sentence, and he can come back to parliament. So again, the absence of reasoning at all levels of the court allows for, again, the Indian courts to play this completely unaccountable outsized role in politics, direct political intervention, one way or the other. The final example, of course, is your classic anti-terrorism laws that are being used to jail political dissidents. So many Indian dissidents who are not politicians have been, jailed without trial under Indian anti-terrorism laws, because these terrorism laws do not allow for bail except under strict conditions. So again, the Supreme Court and other courts are given a lot of discretion in how they can award bail, and that is then used to deny people bail for many, many years. And we have examples of people being in jail right now in India without trial for 4 or 5 years. Trial has not even begun, but they're still in jail. And all courts, from trial court to High Court to Supreme Court, have turned down their bail application multiple times. So these are the different ways in which lawfare is a big issue in India. Some of them, as you can see, are classic lawfare techniques familiar across the world, and some are very Indian, inventions. But the point I want to stress on is that this happens because over the years, the Supreme Court specifically has completely shed all the normal constraints that apply to courts in terms of jurisdiction, standing, legal reasoning, precedent. And this is perceived, specifically abroad, as being a great thing and a great Indian contribution to doing justice. I want to clarify that that's not the case, and this actually is a major source of lawfare in India. So that should be, very clear, especially to non-Indian audiences, because that's where I think in India we all know it. It's abroad where I think there are a lot of misconceptions about the Indian Supreme Court's role and its discretion. So I'll close on that.
Thank you so much, Gautam. Yeah, I mean, I'm also not an expert on Indian law or Indian criminal law, although we've done some events on, for example, the sedition panel that you and Rocío mentioned was about I guess then Indian Penal Code's provision on sedition. But yeah, I agree with you 100% that from the outside, to the extent that anything from the Indian law kind of sphere penetrates the consciousness, it's about the Supreme Court, and it's about how it's so very special and free of all constraints to be as activist as it wants to be. So I think it's a fascinating comment and troubling beyond the lawfare context. So last but not least, Tyler, the true lawfare expert, and as I think Rocío would say, stricto sensu, in some sense, since you're actually working for lawfare. And I'm delighted that you agreed to join us, because I know that you've been very busy. You probably still are very busy with the various Trump happenings in the US. But one of the reasons why we thought it'd be great to put this on was because lawfare seems to have spread in the US, fairly recently, and in this domestic sense. And so I'm delighted that you've agreed to join us, but also because I know you have done work in Latin America kind of more generally. So I'm very much looking forward to your presentation.
Yeah, no, thank you so much for inviting me. This has already been a wonderful panel, and I'm going to pick up on a few things that Rocío talked about, Valeria talked about, and Siri talked about. So I may not take the full minutes just so we can have more time for discussion. But as you mentioned, our publication is called Lawfare. So I also want to apologize, especially to Mark, if we made your Google searching more difficult. Yes, we are published in cooperation with Brookings, and no, we are not affiliated with the Brazilian Lawfare Institute. So thank you as well for that. And another caveat again that I'm a journalist. So these are my own observations, and I'm especially wary of the fact that the term is getting a lot more take up in the United States context, but I'm sure a lot of Latin Americanists and comparativists are like, welcome to the party. We've been talking about this for a long time. Just because this is the first time you're prosecuting a former president doesn't mean it's a new term by any means. And it is quite interesting how it's the migration of the term from the global north to the global south and back to the global north is fascinating, and I'm glad someone brought that up. But I'll start with just a brief story from when I was reporting on the trial in New York of Donald Trump, because I think it illustrates this main point I want to get across, which is actually something I believe that Siri first brought up about how the allegations of lawfare can be a form of lawfare in itself, or can make the term almost empty and malleable, and kind of explain why it's getting so much traction in the United States at this point. But this is back on May 29th. So it was the day before the verdict was delivered in New York. Of course, we didn't know that yet. We're still waiting on jury deliberations. But it was right after the judge, his name is Justice Juan Merchan, delivered the instructions to the jury of how they should deliberate. And right after he delivered his instructions, there was a tweet or a post on X, aka Twitter, from a Fox News anchor named John Roberts, who said, Judge Merchan just told the jury that they do not need unanimity to convict. 4 could agree on one crime, 4 on a different, etc. The point here being that he was claiming that the judge was not requiring unanimity, which is a constitutional right for defendants in the United States. And it seems like a pretty spurious claim at the time, but I almost watched it play out in real time, how this form of disinformation or this claim just spread throughout especially the right, American right ecosphere online. And it was too late. I mean, some people quickly pointed out that this was not true, but almost immediately you could see the right take it up and then attach the word lawfare to it, and just helps bolster their claim of lawfare that's being perpetrated against former President Trump. And so I think this illustrates that not only it's so easy to invoke, and it's so powerful and just spreads so rapidly, but also that you sort of can't unring the bell, once you've rung it. This happened quite a few times throughout the trial. This didn't just happen at the end, where you would see especially Donald Trump and some of his supporters taking these sort of mundane, almost normal legal procedural things and flip them on their head to make a claim of lawfare being perpetrated against them. So just a few quick examples. Early on, there was this discussion of whether Donald Trump's presence at the trial was either a right or a requirement under the law. It's a bit of both, in my understanding. But it's interesting because this sort of right to be present at your own trial is often thought of as beneficial to the defendant, so you can be there and defend yourself, etc. But he flipped it on his head, saying, I'm being kept from the campaign trail. I can't attend my son's graduation, and this is just part of the narrative of persecution that he is, sustaining. This went on and on, from very simple things to including that the fact that the prosecution got to give the last word, go last in closing arguments, which is a very routine thing, to some, more, I think, genuinely confusing aspects of the case. And I think the case itself was complex, and it wasn't without its issues. And in the grand scheme of all of the prosecutions against Donald Trump, this did seem, I think, the least serious in many ways. But again, I think to Rocío's point, it was in my understanding and my observations, quite a legitimate case, and there was strong, compelling evidence that the law was broken. So, I think in overcorrecting against lawfare, you could go so far the other direction that no politicians are held accountable. I'll also add that a few people have brought this up, but my observation that Trump's use of lawfare, the invocation of it, is not only to delegitimize. I think, let me back up. It's for three reasons, I think. First is just pure disinformation, to sort of flood the zone with a mix of, you know, these strange, mundane claims to more legitimate ones, and just anything that sticks is worthwhile for him and his supporters. It also serves to delegitimize the entire legal system and legal institutions. I think this is fairly clear in motivation. But then lastly, it's used, I believe, to justify then the right's own use of lawfare, or planned use of lawfare. There's been a lot of reporting on what Donald Trump plans to do if he is reelected as president, and a lot of it is motivated by revenge against people in power now, and especially using the Justice Department and things like that. I will also add that, you know, one time that it was not invoked, interestingly, was the Supreme Court case in which many people were trying to disqualify Donald Trump from his candidacy because of an amendment to the Constitution which prohibits insurrectionists from running for office. That one went his way. You know, he was not disqualified from the ballot. There was actually quite a robust conversation that he should be defeated at the ballot box rather than in the courts. And conspicuously absent from that conversation was the invocation of the term lawfare, interestingly, at least as I saw it. I'll also mention that I'm far from the only one, you know, pointing out these allegations of lawfare as potentially damaging to the entire legal system. Just the other day, the federal Attorney General Merrick Garland wrote an op-ed in the Washington Post in which he cautioned against these attacks of the Justice Department and the legal system in general, and warned against a lot of what I'm talking about here. But I want to end with something that I'm tracking and a bit worried about is the potential for lawfare to erode legal institutions to such an extent that it does actually lead then back to warfare, or in other words, political violence. And I think it's telling that Merrick Garland began this op-ed with the case of someone who was accused of quite credibly of a bomb threat against you know, legal officials. So I think there's been discussion of the benefit of replacing lawfare with warfare because it's less violent in a way. But I'm worried in at least in the US context of lawfare then easily sliding back into warfare. And with that, I will turn it back to you, Marcus.
Wow, thank you so much, Tyler. Clearly, you have a lot to say on this, and I can also see why, as a journalist, you know, you are kind of playing a different game than we all are playing. So I really appreciate your willingness to kind of share your insights and experience with us. So we've kind of come to the end of the second panel. But I want to invite everyone to now, you know, pose questions to the members of the second panel, or to pose more general questions. So the floor is open. All right, please go ahead, Mark.
Oh yeah, thanks so much. Really interesting. I also feel like we're getting really into some nice deep corners to this. My question maybe is more for Manuel, but anybody can play in, Rocío, you as well. My question was about institutions. So I also work with the Spanish case, and as you said, Manuel, there is sort of a legacy of a far-right dictatorship. What's the role of institutions like, for example, La Audiencia Nacional in the possibilities for what Siri called this room, the discretionary room for lawfare? What's the role of institutions in this, do you think?
Well, the Audiencia Nacional is an anomaly that stems directly from the political tribunals, who should certainly know the Tribunal de Orden Público during the last period of the dictatorship. So it is a tribunal. Also, the Supreme Court, of course, because it's the court that has jurisdiction over members of parliament and government. But the Audiencia Nacional is the very central tribunal to get anything that is important in the whole of the state. So in the procedures against the Catalan separatist leaders, the Audiencia Nacional asserted its jurisdiction. And this was taken after this by the Supreme Court. In my opinion, in the opinion of, I would say, a majority of jurists, there wasn't any jurisdiction of a tribunal in Madrid. The jurisdiction would have gone to the courts in Catalonia. So it is a centerpiece of this survival of the deep state. In Spain, we use very often the idea of deep state. So it's a particular kind of lawfare in the sense that you don't have an absolute marginal person like Bolsonaro or Milei climbing up to power. Here you have, as they used to be called during the dictatorship, the factic powers, the deep state. So it's a different kind of lawfare, I would say, because it comes from the heart of the state, in my opinion. And the Audiencia Nacional plays a very important role in this. You're right.
Valeria, please go ahead. Yeah.
Thank you. So I just want to clarify that it's not that we need to worry that lawfare will not be in the agenda. Unfortunately, it will be still, even in Argentina, because it's probably the case that the right-wing extremist government that we have today is a byproduct of lawfare, because the leader of the Social Democratic Party was not able to present herself in the elections, the one that would have a better results in the ballots, because she could have been targeted by lawfare and criminalized, the same that happened with Lula. So we can really understand even today's scenario without lots of accusations of lawfare as a result of lawfare. And now to the question, I wanted to ask Professor Cancio Meliá, even if you say that you're not an expert in lawfare, you have studied in depth this notion and developed the notion of criminal law of the enemy, or enemy criminal law. So I wanted to ask you if you could relate these two concepts and explain it a little bit further for the general public what this concept entitles. And to Rocío, I was wondering, so I understand which is with your reasoning, but with the situation that we were describing in Argentina, in Spain, and even in India, where the judiciary has not experienced the democratic transformation that other branches of government had, where the judiciary is not accountable, where it's extremely right-wing and politicized, where there is no absence, when there is an absence of reasoning in the judgments, do we actually have those defenses that you mentioned in terms of having a chance to confronting the misuse of the law? Or these defenses are actually only rhetorically mentioned, but they don't exist in the actual functioning of the criminal justice system, and we then need the conceptualization of this phenomenon to at least be able to frame which is the situation and explain why, even though the case doesn't have enough grounds constitutionally or criminally speaking, there is no way to achieve accountability, and we have to, for example, wait, as in the case in Spain, to have a new government that issue an amnestia in order to put an end to lawfare. Thank you.
Well, I was hoping Valeria was going to explain to me the relationship between one and the other. I'm sure you have your own opinion. I would say, let's say, enemy criminal law is defined by being an exception criminal law, which is directed against a group of persons. That could be, let's say, an open definition. So, and in order to achieve this, of course, you take the whole of separation of powers, of right to due process, the principle of legality. All this goes away, of course. And the thing is, because this is a very flexible criminal law. We heard before in India, terrorism is used. Why is terrorism used very often in lawfare cases? Because it's easy to be manipulated. But we don't need this. We had in the first proceedings against the Catalan leaders, we had an old offense that every country has, the offense of rebellion. So they invented just the prosecutors and the tribunal, the Supreme Court. They just invented a violence that didn't exist. And I must add, I'm no friend of Catalan separatists, but there wasn't any violence but the violence of Spanish police forces. So to make lawfare, you don't need enemy criminal law. It makes your life easier if you want to just to bend the law, as the Supreme Court, in my opinion, has done with the Catalan politicians. So I would say it is two different concepts that on this political arena can have confluence. Thank you for your question. I should have posed it to me myself before.
So I'm gonna jump in. Yes. So yeah, I agree with Valeria about that. The concept of lawfare becomes particularly important there. I mean, where judicial institutions are, not fully working for whatever reason. However, I think I would still resist I still unconvinced of the concept because of the risk of using it for other purposes. And I mean, I think if we're going to have the concept, and since it's there, it's really helpful what you're doing to okay, let's find ways to distinguish what are the features that would make a case of lawfare really a problem. And I think probably that's the way to go because the concept is there. I'm just playing devil's advocate or whatever. But so in Chile, we had when we went from dictatorship to democracy, our judiciary during the dictatorship basically played the game of the dictator and, served to legitimize power and was very corrupt. All 15 judges of Supreme Court were right-wing, And so what Chileans did was, instead of kind of deepening our distrust from Supreme Court, we altered part of the agreement we had was to alter the conformation of the Supreme Court, and we added 9 more judges. And that were elected, they were not elected democratically, but during democracy in a kind of a better system. And so I think the problem there is with the judiciary. And I have the feeling that it's better to confront that directly and to, expose that the judiciary has been co-opted by political power and how we can what institutions need to be arranged, how we can change it, and what kind of inner controls we have to have, instead of raising this kind of a keyword that raises a general mistrust of the legal institutions. Just because of what Tyler was saying, I see this operating very powerfully to continue to kind of keep some people beyond the reach of the law because they say, oh no, the law is corrupted. So and I think the worry today in the world is the impunity. And so for me, anything that could be used for impunity seems more dangerous in a way. But that said, I think it's great to analyze the concept and create conceptual nuances. So Yeah, so I guess that in those cases, I think the concept maybe has a greater power than in a different kind of case. Thank you.
Yeah, no, I want to thank you also. In the meantime, we have a long series of very provocative questions that showed up in the YouTube chat, and I'm tempted to read them out to you, but it would take some time, and then also for you to respond. So I'm going to apologize to the person asking these questions in the interest of time, that we won't be able to get to them. But I think we've addressed actually them in a different context. Since we're already 15 minutes over time, and we could do this for for days probably. I would like to do it for days. So how about we do it? No, I'm kidding. I thought I would give each of you an opportunity to briefly, a minute or so, however long you'd like to take, to share your final thoughts, whatever you'd like to share, a specific point, or lawfare, yes or no, useful, useless, danger, opportunity, whatever angle you'd like to take to kind of take us home, and then we'll close our very very fun, and to me at least provocative event. So who would like to start?
Well, then I'll start.
Thank you.
It has been very interesting for me, and I'm old enough to know that not all seminaries are interesting. And it's very interesting. The main issue I take home to think about it was what Rocío said. Do we shoot us in our foot if we use this term regarding Donald Trump? Or should we take advantage of the force of this term to show what is happening? I'm not sure what it is. Everything else was very interesting, and especially I will have to think what criminal law drafting is prone to lawfare. It was very interesting. Thank you all.
Thank you.
Well, I will continue. Yes, I want to share with Manuel that it has been very interesting, and I've learned a lot. So thank you very much. And I just want to say two things that weren't said, and I don't know how your legal systems are, but in Chile we have a few crimes that are related to what we call here lawfare. We have one that's called denuncia calumniosa, that it's about, and calumnias that are about, a kind of the first one particularly about instrumentalizing the judicial system to damage someone. And so you accuse someone of a crime, and you make the legal system go into an investigation when you knew there was no crime. So we have this, and it shows, these are old crimes. So it shows that we've been dealing with this for a while. And we also have, and you probably also have, a lot of protections for people who hold public office, that you can't just sue them. And so if you want to sue them, you first have to go to a special judge that will see if you have good arguments, or if you're just doing this. It's a kind of immunity, like a prima facie immunity that you can overcome. And I think this also shows that, for a long time, we've been sometimes targeting our political contenders through the legal system, and the legal system can create some kind of structures to diminish this problem. Thank you.
Okay, I guess I think I'll go. I also have to say thank you again. For me, I think, and that's why I started my presentation with that. One reason why it's nice to talk about lawfare is because people are talking about it. So it's nice that we in academia can sort of weed out what we actually mean by it, so we can actually try to have some clear concepts on this. What I think is good about the concept. One thing that's bad is how that it can be very narrow and very broad. My own definition is very, very broad, for example. and as you say, Rocío, within putting too much into the same box. What I like about it is that it encourages conversations like what we have now. So about interdisciplinary talks about the relationship between politics and law. And I think that the concept is good for that. In that sense, I'm also reminded by the quote by Foucault that modern statecraft is when judges do something other than judging. They are required to make politics. And there, I think, are we seeing it more? Maybe in Spain 10 years ago, we wouldn't have said perhaps that we saw it more. Now we see it a lot. Argentina goes up and down, Brazil and the US as well. So maybe it's constitutive of modern politics that we always instrumentalize the law, but there can be cases where there is more judicialization or more politics in law and more law in politics. And there I do find it interesting to still talk about lawfare. So thank you for doing that.
Thank you.
Well, thank you very much. And I think that I am lawfare, yes. And I just want to raise like three points about it. One is that I think that lawfare allows us to expose the importance of the rule of law rather than being ourselves shooting our own feet. And it also exposes the risk of violating the rule of law that can be even causes damage to liberal democracy. I think that lawfare can also help us to expose the inequality and the unfairness of the criminal justice system as a whole, because all the things that we have been pointing out from the different case studies, they talk about things that are common sense and something that happens every day to the ordinary prisoners, like abuse of pretrial detention, unconstitutional measures that go against their privacy, wiretyping, plea bargain instead of having the right to trial. So if we do like as Manuel was suggesting, and we explore the ways in which criminal law can really make lawfare less possible and can reduce the opportunities to conduct lawfare, we might be strengthening the criminal justice system as a secure place and a safe place, a place that is kind with the rule of law for all. So instead of using it as a critique that can damage the relevance of the rule of law and the relevance of having a strong criminal justice system that respects human rights, we can use lawfare maybe as a path to create a system that is more fair for all.
Okay. I didn't really want to go last, but I'm going last. I'm not certainly not wrapping anything up. I'm probably taking away something that's quite different, or a couple of things that are probably quite different from, what everyone else is taking away, because my, perspective on this is quite different, being from cultural studies. I think it's really got me thinking about the whole process of the development of the term in Brazil. And the different kind of factors that have played into lawfare becoming this term that then gets discussed in this kind of environment. Not that Brazil is the reason why we're all here talking about this, but it's probably quite instrumental in very many ways. And all the different things that have played in, the role of the media, the actual media savviness of the people behind the term, so Zanin and his colleagues, and those different kind of aspects that have brought us to where we are, I think could very well be interestingly explored, further from perhaps a cultural studies angle. So there's plenty of food for thought there. What I didn't mention was that Meliá Augusta Helmus went on to make the documentary that she made immediately after O Processo, the trial, was all about Vaza Jato. So this was the second bit of the Lava Jato, the car wash corruption scandal, where information got, sort of drip fed from the media about, conversations that have been recorded and the implication of the judge that was involved, which then led to, sort of the release of Lula, et cetera, et cetera. And that was very firmly within this concept of lawfare. So it's something that's probably, for me, worth exploring further and thinking about how cultural production has picked up on this term and how it's using it and how it's supposedly helping people to understand what goes on in Brazil. And I'm kind of, as a sort of thinking further about that, I was struck, I think Valeria had mentioned, that lawfare produced what's happening now, in politics in Argentina. And I'm sitting thinking to myself, well, Bolsonaro was a product of lawfare. And I wouldn't dispute that, but I guess the problem with that is that then that becomes quite reductive in so many ways that things have been reductive. When we've talked about Bolsonaro and Bolsonarismo in Brazil, and not actually trying to get to perhaps what was the actual root of that kind of shift towards the right. And so to blaming that quite easy concept of lawfare perhaps is a danger. Yeah, I'll leave it there.
That's a wonderful communal summing up, and so I wanted to thank you all for participating, for sharing your thoughts from all these different places and perspectives, and yeah, we all look forward then to the publication of the online forum that will be based on this event, and thanks everyone for joining us today. And I hope you have a wonderful rest of the day and weekend.
Thank you so much.